That bill was exposed as a consultation draft by the government in October last year and was the subject of many hundreds, in fact thousands of submissions. There's a Senate committee report that deals with it, and what that Senate committee report suggested was that we have another look at a number of aspects of this consolidation process. It's of course a very worthwhile idea. It consolidates the 5 acts of Parliament that make up our body of anti-discrimination law enacted over 4 decades. I've had the department looking at those suggestions made by the Senate committee since the report was handed down. It would be the government's intention to go forward with the anti-discrimination consolidation project, because I think it's very well regarded by almost everybody who's had a look at this. It's appropriate that you consolidate where you've got the unevenness and partial coverage that is involved in having legislated over 4 decades. So I've pulled out of that consolidation draft one measure which we thought was too important to be left on the table, and so we have now legislated the additional ground of discrimination for sexual orientation, gender identity and intersex status. We've gone forward with another smaller measure there, which is the removal of the exemption for the aged care sector, but the rest of the measure is going to have to wait until after the election. In 2010, in April 2010, on the conclusion of the Brennan report, which was conducted through 2008, there was in fact the biggest consultation that's ever been in Australian legislative history. So more than 40,000 submissions were made to the Brennan Human Rights Consultation. He conducted meetings in more than 80 towns and cities around Australia. His report was received by the government, and the announcement that the government made in April 2010 was not to go forward at that time with a Bill of Rights or a Charter of Rights. There were various recommendations in the Brennan report, but rather to adopt a national human rights framework. We've done that. To introduce the Parliamentary Committee on Human Rights, which has occurred, to introduce a statement of compliance with human rights that now has to accompany every piece of legislation, and importantly, in answer to your question, to review the ongoing need for further changes in our human rights regime, and that review would occur in 2014. So I can confirm that if the government is re-elected, we will be conducting that review in 2014, looking again at the recommendations of the Brennan Review, considering whether some of those recommendations now need to be acted on in addition to the measures that we adopted in April 2010. Both of those are under active consideration. I'll just speak about the optional protocol against torture. The optional protocol to the Convention Against Torture. What that requires, because our system of imprisonment in Australia and our criminal justice system is very largely under the control of states and territories. For example, there are no federal prisons in Australia. If you are convicted of a federal crime in Australia, you will be imprisoned in a state or territory prison. We need to reach an arrangement with every one of the states and territories before we ratify that optional protocol. That's in train now. We think it's appropriate that we carry out that consultation with states and territories to make sure that they are ready and prepared for the international inspections, which we think are appropriate. We think that it's a good idea. It is the government's intention to ratify the optional protocol, but we don't want to do so because of the consequences for each of the states and territories until they're ready for that to occur. In some cases, they may need to pass state or territory legislation in order to make sure that it's possible for the international inspections, which is the key to that optional protocol, to take place. We don't think that it is a penalty for someone who arrives here to be transferred to another country that is a signatory to the Refugees Convention. That's not what penalty is referring to in that provision of the Refugees Convention. It's a short answer, but that's the position. I've already answered that question a bit earlier, but we think it's a very important measure that protection against discrimination on the grounds of gender identity, sexual orientation already appears in states and territory legislation. Intersex status is new, so we're ahead of the pack on that, indeed ahead of most countries in the world. The government thought that this was too important a measure to await attending to the detail of the recommendations of the Senate committee, which are some of them quite far-reaching. This was a single standalone measure that was included in the consolidation draft, but was able also as a single measure to be pulled out and made the subject of separate legislation, which very happily has now passed through both Houses of Parliament. The recent amendments to the Privacy Act, which come into effect in March next year, take forward an extension of obligations, really, that I suppose I'd invite you to look at the detail of the legislation rather than... there's a long list of measures that make, we think, compliance more likely, will improve reporting, will improve, we think, understanding of the obligations, particularly in the private sector, in relation to privacy obligations. We've legislated this protection of journalists in respect of not having to disclose their sources unless a court orders, so the prima facie position is that they will not have to disclose. I think it's one of those areas where journalists push for a more complete protection. That's been going on for a very, very long time. In codifying the journalist privilege, I think we've made a useful step, and it's a matter that you have to keep looking at over time to judge whether or not there's been particularly difficult examples thrown up by court decisions where journalists have been ordered to disclose their sources, and whether in the balancing, because like many laws in this area, it's a balancing between the duty of courts and the obligation of courts to function and to find the truth, balancing that with court powers against the freedom of speech or protection of journalistic endeavour in Australia, and the good that that provides to the community. Whether or not we've struck the balance in the right place is something we're going to have to keep under review. That's a question we're going to have to continue to look